Court rise. Appeal in the matter of the Good Law Project and the Minister of Cabinet Office and Anor.
Yes, Sir James.
My lords, my lady, good morning. We've agreed something of a timetable and something of an order, subject to any views the court might have about order. And the timetable, subject to your permission, goes roughly like this. I am going to be opening what's become known as Ground 3, which is apparent bias.
So this is your appeal?
This is my appeal. And I estimate that I will be about an hour, possibly a little more. Then my learned friend Mr Coppell is going to go and is going to do both a response to the apparent bias point and an opening of his appeal on what are called grounds 1 and 2,
yes.
The procurement, the pure procurement stuff. And he thinks he's going to be roughly 2 hours. Then Mr Boucher is going to take over the reins from me and respond to the procurement
yes.
bits. And then hopefully, and he's going to be about an hour as well. And then hopefully at the end, we've got 15 or so minutes for both of us to do a reply.
Yes.
Well, it sounds very complicated. But
No. Well, oddly enough, Sir James, it's precisely what we had been discussing just before we came into court. So whether it's great minds or it's so obvious, I don't say.
My lords, my lady, I should give you the cast list. I'm leading Michael Boucher, Ewan West and Annalise Blackwood. My learned friend Mr Coppell is for Good Law Project, and he's leading Mr Halliday.
Yes.
My lords, my lady, I'm very aware that there have been some procedural issues floating around. I wasn't actually proposing to address you on those orally. We can of course do so if you'd like, but there's quite a lot to get.
We're content with that. We've got quite enough in writing on all of those. Thank you.
That's what we rather thought. If there's anything else you'd like assistance on, of course we'd be happy to help, but given the amount we've got to get through, it may be easier for me to just simply pile in. So I'm opening our appeal then on apparent bias. And I'm going to divide the submissions, if I may, into two parts. The second rather longer than the first. The first one is the principled approach, and the second one is application of that principled approach in the context and on the facts of this case.
Yes.
So, so far as the principled approach is concerned, three headings, but with one introductory point which can be stated in a sentence, which is that context, and the context in which one is asking any question about apparent bias is key. And the particular feature of the context that is key is the role which is being undertaken by the decision maker in the context that you are considering here. The first point of 3 to make in relation to the principled approach is that we are here dealing with public authority decision making. Judicial or quasi-judicial roles, as the case law has frequently emphasised, require particularly rigorous scrutiny, precisely because, in the circumstances there being considered, there's a very well and long understood need as an integral part of that judicial, quasi-judicial function to focus solely on the issue identified in the legal framework and on the evidence bearing on that. It might be thought that a judge or equivalent is held to a particularly high standard given the importance of the appearance of justice in that context. And it's highly unlikely that there would ever be a situation in which it would be legitimate to base a judge's judgment of a present issue on the basis of the past performance of a party to the dispute or list. In other contexts, however, that may well not be the position. For example, in relation to government decision-making, which is the context here, in that context, again, as is well established by public law principles, there may well be a wide range of matters that can legitimately be taken into account. And the usual position, as all members of this court will well know, is that it is for governments to decide what factors to take into account. They are given considerable leeway in assessing what factors to take into account in their decision making. The DSD case, war boys and so on, identifying all those principles to do with material considerations. And weight is entirely a matter for the decision maker. So if you're attacking a multi-factored assessment, you would have to show in public law terms that the decision maker acted irrationally. And that feature helps to identify what would and what would not be a pollutant of the stream as illegitimate to take into account. In effect, something which could not rationally or properly be taken into account in the assessment being made. And from the perspective of apparent bias, there is an obvious and clear distinction based on role between a judicial or quasi-judicial function on the one hand and a public authority function on the other. That was the reason for inviting the court to focus on the paragraphs that I identified in the Lewis and Redcar case that I hope came to you overnight. Apologies for its lateness. I did ask that it be sent to
Which paragraph?
all of your clerks. It's really the analysis of Lord Justice Pill between paragraphs 43 and 71. Quite a long section. I'm not going to go through it in any detail now because it's really to show you the analysis or an analysis of that line of case law that draws that distinction.
Well, this takes us back really to first principles in the whole concept of bias, which, tell me if I have it wrong, but I think Mr. Coppell in his skeleton argument reminds us that it's a principle that underpins natural justice, and it's obviously an aspect of fairness. Apparent bias is something which can be waived by one party to a dispute, for example. So I have struggled to understand how someone who is not a party to a contract and not involved in seeking to get a contract can bring an independent public law challenge based upon apparent bias. Because I'm asked, the question is, well, bias against whom? And here we are told that there was really only one other provider, I think, who realistically could have done this job, who's well aware that the contract was let, and who's not concerned, or so it seems. So I mean, Mr. James, I'd quite like to be helped with, if we leave aside procurement regulations, this is a pure public law challenge, which it is said could arise separately from the procurement regulations and can arise in the context of a contract worth less than 122,000, which I think is the current cut-off limit. So we need to have an eye to the circumstances in which there can be a pure public law challenge to a private law contract entered by a public law body, step one, and step two, the circumstances in which apparent bias is one of the grounds upon which there could be a challenge, and then if it is, by whom. I'm personally not aware of any example of a pure public law challenge to a contract brought even by a party, forgive me, brought by somebody who wanted a contract, by an aggrieved tenderer outside the regulations, alleging apparent bias, as opposed to something more directly disadvantageous. and still less by somebody who's a complete stranger to the whole process. And I would like some help on that from somebody, because it seems to me to be quite an important foundational...
My lord, yes.
Well, I'll obviously, Sir James will, I'm sure, be able to help you in due course. If this is an avenue which the court wishes to investigate, then of course we can help, but we can't help today in the course of this hearing, because
Well, let's see where we go. But one of my concerns, at least, is that there seems to be just a general assumption that, frankly, anybody who asserts an interest can bring a challenge to a contract on grounds of apparent bias when nobody is identified as having been disadvantaged. So that doesn't feel entirely consistent with the approach over the last 4.5 decades since the reforms of judicial review.
Well, my lord, that's not, and I'll obviously sit down in a moment, but that is not the point that my lord has made. It's not a new point in this case, because as you will have seen from the judgment, there was a vigorous argument before the judge about whether the claimant had standing, could have standing, to bring this claim, which...
well, that's a slightly different point.
Well, my lord, the very sorts of issues which my lord has raised were ventilated in the course of the argument on standing, and the judge decided that my client, even though not a party to a contract and not wishing to be a party to a contract, had standing.
Certainly, and that's not it's not appealed,
and so isn't appealed. So,
Mr. Coppell, you don't need to argue it now. But I thought it right that we should just expose from the outset some of the thoughts that have been going through our minds, which are not really answered by the materials that are in front of us. Anyway, Sir James.
Yes, I'm grateful for that indication. And I mean, I think at the moment, the closest one comes to assistance on that question is perhaps in the Lewis and Redcar decision itself. And the passages on which, or to which we've drawn attention are 43 through to 71. It's quite a long section, but lots of it is analysing the authorities that lead up to the conclusion section, which starts at paragraph 61. So maybe the best course might be to invite my lords and my lady to read, if you would, rather than me reading it out, the couple of pages and a bit, running from 61 to 71. Would that be a convenient moment? You may not have a... Do you want another copy?
I know I do have a copy, and it's been put in one of my bundles, but it's not flagged. Is there a spare one?
Yes.
There is.
Thank you.
Is my lady in the same position, or have you got it?
My lady has two.
My lady has two. Very, very efficient.
Well, whilst we find our places, is it, however, right to say that in all of the cases building up to the conclusions there is some sort of adjudication going on at some level? Even not judicial or quasi-judicial, but some sort of committee type.
Yes, I think there is. Most of them are in the planning context.
Exactly, adjudicating on competing arguments before the committee.
Yes.
Or on an application for a licence where there may not be competing arguments, but you're nonetheless acting
In a quasi-adjudicatory role.
Yeah.
My lady and my lord, both yes to both. That makes sense. I mean, on one view, that makes our position a fortiori.
But yes, by definition, you were
Your position
not
being,
doing that.
Our position being that there is a clear distinction between that sort of situation, I described it as judicial or quasi-judicial, but I can add in adjudicatory as a role, and the position where the public authority is making a decision in the particular context that we're concerned with.
Yes.
Which is the one that my lord identified.
Yes, well, we'll read all of those paragraphs again.
Oh, I'm grateful. But in the end, if I can summarise it in a sentence or two, where the court gets to is to say, well, you don't have the same approach when you're dealing with public authority decision making, even in that context. You end up in a position, in effect, where the public law control over the decision making is whether or not the decision maker has made rational judgments about what to take into account and has come at the matter with, in effect, an open and unclosed mind.
There was never any suggestion of predetermination on the facts here in the sense identified in these authorities.
No. I've given you that long section. There's a pretty crisp summary of the relevant principles in paragraphs 94 to 96 of Lord Justice Rix's judgment. And you'll see the reference at the beginning of 96 to the point I just made about closed mind. And so looking at the planning context they were considering there, the court makes the obvious point that people come at planning decisions as ministers no doubt come at decisions, in effect party pre to the issue. They stand on a platform that says we're thoroughly in favour of the housing development outside the town, and then they sit on the committee deciding whether there should be a housing development outside the town.
Yes, thank you. Well, that does in part go to the issue that we were concerned about.
We can no doubt both. I mean, in fairness, my learned friend, that's a late authority, and that's my fault. But that at least comes a little bit closer to it, and that obviously leads on to the second of the points, which is that the approach, if you are to use it as an analogue, that was designed for the doctrine of apparent bias, is now very well understood and very well established. And it is that set out by, in particular, Lord Hope in Porter, paragraph 102, tab 7 of the authorities bundle, page 235, using the internal paragraph numbering of the page numbering of the bundle, but it's quoted in our skeleton at paragraphs 19 to 20, and it draws on, if not exactly replicates or quotes from, Lord Phillips in Medicaments, which, as you will recall, was the case in which there was an argument essentially about whether or not the common law doctrine of apparent bias absolutely mirrored, or whether there was tweaking needed, the doctrine of appearance of impartiality under the European Convention, Article 6.
Yes.
But that test is now very well established. You focus on bias and all the circumstances bearing on that. Then you ask whether they would lead a fair-minded and informed observer to conclude that there was a real danger that the decision maker was biased. You approach it with a degree of caution and circumspection and inherent fair-mindedness. The informed observer is not unduly sensitive or suspicious. The informed observer is not the person raising the complaint. They don't act on the basis of preconceptions or first impressions, and they consider the evidence carefully. In a nutshell is the approach. So if you're applying directly that test, that is the basic approach, and there doesn't seem to be much dispute about it. But it is important on any view, and this is a submission that we've made throughout, that you draw a distinction between judicial/quasi-judicial on the one hand and public authority on the other, to which Lewis and Redcar goes, if not quite directly, at least in relation to a context in which there is some form of adjudication, but not of the quasi-judicial or judicial kind. That's the first and second, perhaps 1A and 1B, part of the principled approach. The second thing to bear in mind about the principled approach is that we're here dealing in a context in which there is a body of rules governing procurement. And those rules of procurement are set out in regulations that derive from EU law or EU directives. And there are two particular rules that may be interesting to bear in mind when considering the apparent bias issues. The first is Regulation 24, which is set out in our skeleton at paragraph 5. And the key points on Regulation 24 to note are that it anchors conflicts of interest, which is the concept used there. It anchors conflicts of interest into the procurement context, with that idea being part of the overall objective of the rules in the scheme, which is in essence, to use the wording from Reg 24, to avoid the distortion of competition. But Reg 24 also does have a specific reference to appearances, with its focus in paragraph 2 on a, quote, personal interest which might be perceived to compromise impartiality and independence of the decision maker in the context of the procurement procedure. There appears to be a recognition that some form of appearances is built into that as well as actual bias. But we invite two things to be noted about Reg 24 at this stage. There is nothing to suggest that there's anything wrong or contrary to Reg 24 in a person in the contracting authority having prior knowledge of and professional and or personal relationships with entities or individuals whose offers are under consideration. Indeed, that may well be, especially in a narrow market, part and parcel of the decision making. And an insistence on any such approach, where that is problematic, would itself be intensely difficult and highly unlikely to have been intended given the context we're dealing with. Secondly, there is nothing to suggest that there is some form of consideration of other agencies required as part of the Reg 24 conflicts of interest taxonomy, if you are in a situation in which the urgency rules set out particularly in Regulation 32 are in play. When I say there's nothing to suggest, what I mean is there's nothing in the text of Reg 24 to suggest that, and there's nothing that either party has been able to ascertain from the case law to suggest any such requirements within that. So that's Reg 24 for the moment.
There's nothing the other way either. There's nothing that says, effectively, in Regulation 32, if it's urgent, you disapply Regulation 24.
My Lord, yes, and that's why I'm going to come back to that point, if I may, to explain precisely what our position is, because there's a dispute about how far we go on Reg 24. Yeah. Is it truly what might be called a lex specialis? Can I come back to that in a second?
Of course. Yeah, no. I just you were saying
but I agree.
Regulation 24 didn't say, which I completely understand.
Yeah. You were pointing out there's a degree of neutrality about it. I agree. Reg 32 is the other one that's in play. I'm not going to go through the detail of that. Mr. Boucher will no doubt do so. But we note at this stage that there is in effect an exception created by Reg 32 to the usual procedures and rules when you're dealing with situations of real urgency. So, in effect, bypassing the competition benefits involved in considering other potential contractors is acceptable under the scheme, subject to the conditions that are laid down in Reg 32. And there's no requirement in that rule either, governing what you can legitimately do and when you can legitimately do it under the urgency provisions, that you say as part of that you need to consider others. So what's the significance of those rules? We submit that they provide on any view a key part of the context in which the consideration of the case of apparent bias sits, and by the case on apparent bias I mean either the case under Reg 24 or the case under the common law. They provide, we submit, no positive support, at least, partly the point my Lord Justice Coulson has just put to me. They provide no positive support or springboard for the findings made by the judge against us. In other words, there's a need to consider others and make a record at the time as to why they were selected against objective criteria. They provide no springboard for the findings made by the judge, which appeared to be pure common law findings. Not entirely clear what reliance she actually placed on Regulation 24. She certainly cited it when it was cited to her, but she appears to have, as it were, cited it and then moved on to the common law without more.
I think at one point she suggests it's concerned with actual bias.
Yes, although that can't be right.
No.
On the
Given your
face
point about it says perceived.
it says perceived. There's definitely an element of appearance in there. You can't read Reg 24 any other way. But I'm not holding that against her.
No.
We say that the court doesn't need to get into the territory in which you need to resolve whether the common law imposes more onerous requirements than Reg 24.
Sorry, Sir James, going back to that paragraph 149 of the judgment, her
Yeah.
focus really is on avoidance, not actual conflict. So she's saying Regulation 24 is about avoidance. It is a very process-driven regulation, isn't it?
It is a very process-driven regulation, but I wouldn't mind it at all if it was all to do with actual conflict, for reasons you can quite understand.
I understand.
But I don't make that submission because of the content of Reg 24 too, is the short point. I was on the point that we respectfully suggest that the court doesn't need to get into the territory in which you need to resolve whether the common law imposes more onerous requirements than Reg 24. We do say there's nothing to indicate a breach of Reg 24, but we also say there's nothing in the common law to lead to an insistence on the two things that she said needed to be done in order to avoid an appearance of bias. But in principle, it is difficult, we respectfully submit, to see why there should be a really sharp distinction between the regulations regime and the common law, subject to the discussion we were having earlier based on Redcar. Both can, in principle, focus on appearance. That's both the regulatory scheme, the regulation scheme, and the common law. Both would be very alive to the procurement context. Indeed, it's the actual context for the regulations. It must be right that one takes into account the realities of that context, procurement, possibly narrow market, knowing people and so on, and it must be right that the common law would take into account any specialist rules that are in play when taking a decision that is said to be infected by apparent bias. So we rather suspect that the position is going to be a bit like medicaments, where the contrast was between the common law and Article 6, and that all that was truly required was a minor bit of tweaking to the common law to bring it in line. Here, our case is that there's been a breach of neither Reg 24 nor the common law based on apparent bias, and there's never been an allegation that Reg 24 was breached. But I don't need to go as far as to say that if you were to conclude, despite all of that, that there was a breach of the common law on our facts and in our particular context, that wouldn't also ground a similar finding under Reg 24 on our facts. And it's for that reason that we suggest that there is no need to get into the hard-edge question as to whether or not one regime is truly to be regarded as the lex specialis in this context. And that, to some extent, is based on the idea that my Lord Justice Coulson was putting to me, and that I accepted, namely the neutrality of Reg 24 and the case law. One can well envisage a situation, for example, in which But whether it's Reg 24 or some other part of the scheme of the regulations, for the sake of argument, suppose that the CJU had produced a judgment that said this bit of the regulatory scheme means A, B, C, but does not mean D and E. And let's assume for the sake of argument that the common law might otherwise say that D and E would be required in that situation. Quite hard to envisage a practical situation where that would be so, but theoretically that could arise. Well, in that situation, you would have, as it were, the grounding for the hard-edged disputed principle about whether the regulations truly could be said and should be said to trump the common law so as to represent what I keep describing as the lex specialis, in the strict sense of that word, or that phrase. But we're not, I respectfully submit, in that situation on the facts of this case. And that was the reason, just to flag that possibility to make sure that the court was alive to it, that was the reason for inviting your attention to a case which ultimately was all about alternative remedies, as you've seen, the Coulson and Clegg and the MOD case, and that short passage in paras 17 to 18 of Lord Justice Buxton's judgment, which, as it were, at least appears to acknowledge that in certain circumstances there might well be a situation in which a specialist body of law governing contract awards should be taken as in effect setting out the exclusive principles to be applied by the courts in that context. As I say, I don't invite you to go here now, I don't say it's necessary to go here now, and I do accept that there is a neutrality in the case law on what Reg 24 means and what its boundaries are, and indeed in the text of Reg 24.
So you don't press your second ground to
So
its
I don't
absolute...
press
you don't press it.
And you'll have seen that there was something of a movement. I hope it may have been too subtle to have been noticed. But
For me, Sir James, is
something
that what you're trying to
something
say?
of a movement.
Yes.
Something of a movement between that rather stricter and harder age position and the position we took in our skeleton argument.
Yes. Thank you. Just, you say the two things the judge said grounded the apparent bias. Can I just be clear about that? And that is paragraph 168 of her finding, the failure to consider any other research agency.
Yeah.
And then 147, incumbent to make a clear record, although 147 doesn't appear in the ultimate finding.
That's what I meant by the shorthand.
The finding in paragraph 168 that there was a failure to consider any other research agency. The basis for that finding, was there an explicit statement that even if subconsciously there was no process, what was the evidential position on that issue?
Well, I think in fairness to the judge,
Yes.
That 168 finding is properly to be viewed against the backdrop of the 5 findings that she made between 159 and 163. I don't want to do her a disservice because the 168 paragraph is a summary and there are some factual findings which I'm going to make some brief summations about in those paragraphs. But I think that in fairness to her, that's the basic structure of it.
Thank you.
Can I come?
Those are the two things that you were referring to.
Those
Yes.
were the two things I was referring to, I hope,
Yeah, no.
appropriately by way of shorthand,
Yes,
of
yes,
course.
thank you.
But I'm grateful for that indication to draw out her reasoning. But I think in fairness to her, that's the way it's structured. Can I turn to the application of this then? And the 6 of them, I'm going to make 7 points, if I may, and the 6th of them is going to descend a little bit into those paragraphs, those 5 findings, but not too far, if I may, recognising this is an appeal and you're a court of principle primarily. Application then. The first submission is that we're not dealing here with a judicial or quasi-judicial procedure. And that means that you're dealing with a public authority and you're having to consider apparent bias or the public law approach in the context of a procurement procedure. I made the point already, so I simply restate it at this stage. But secondly, flowing on from that, and again I've made it already so it can be stated, this is instead a decision made by a public authority in a particular procurement setting. And I'm going to use the shorthand of Lord Hope, the informed or intelligent observer, assuming that's the test or the standard I have to meet without prejudice to all the submissions I made earlier about the feathering that is needed because we're dealing with a public authority, the informed observer would well understand that the decision maker could legitimately and indeed would be expected to bring to mind their professional assessment of who was best suited to do the job. All of the factors that couldn't be excluded as irrational could be expected to be taken into account by the decision maker, and we submit there's no distinction in that respect between the approach under the common law and the approach under Reg 24. They would understand, therefore, that a wide range of factors were therefore potentially within the proper scope of consideration. Thirdly, coming closer to the nub of it, on the judge's findings, the rules of the scheme governing urgency, that's the rules of the regulation scheme governing urgency, Reg 32(2)(c), were in play and were properly applied and conformed to. And that is very important for obvious reason. The relevant findings of the judge are summarised in our skeleton at paragraph 14. Mr. Bausch will no doubt come back and address some of those or the challenge to them. But when you're considering the appearance of conflict or an apparent bias case, the observer would therefore well understand and would be operating from the premise that the decision maker was permitted to do things urgently, in effect on an emergency basis. And that obviously has a bearing on the question, well, if they're justified in doing that, where's the need to consider other providers, which is the absolutely key thing which 32(2)(c) allows you not to do. And here, for obvious reason, there was a clear and pressing need, as the judge found, for the urgent organisation of focus groups to enable the messaging to be got right at the very outset of the pandemic, if we can ever all throw our minds back to the state of affairs we were living in then, with the urgent need to make sure that that messaging got out there effectively for the purpose of seeking to save lives. It was a time in which if, in the judgment of the decision maker, the best were out there, the best needed to be retained. Perhaps especially so if you're dealing in a market, which the evidence bore out, in which the quality was, at least on one view, varied. And where you were going to need, given the nature of the decision making and the urgency with which it had to be undertaken, clear trust in those whose judgments were being brought to bear on that set of issues. So that's the third point. The fourth point is that it's entirely legitimate, we submit, to bring a professional judgment to bear about the abilities, performance, strengths and weaknesses of the entity or persons that you are considering for that role. No one gainsays that, and the judge rightly did not do so. The informed observer would know of the market, would know that it was a small and close-knit market, would have an understanding that in those circumstances there was a relatively narrow group of players, and would know that the people who were operating in that market and those who might commission their services, both of them, as it were, depended upon strong elements of judgment. We're dealing here with personal service, not with widgets. Specialist market with niche elements. And in those circumstances, the intelligent observer would positively expect that. It's a virtue and not a vice that sort of judgment is brought to bear, that those elements of trust play a part in the decision making, and it's inevitable that there will be knowledge of the players in the market. And indeed, I don't invite you to turn it up now, but that was precisely the sort of point, that was precisely the point that was made by the Privy Council in Pratt. The the relevant paragraph is paragraph 47, tab 8 of the authorities bundle, page 264. That's the fourth point. The fifth
Could
point...
you say the paragraph number again?
Yes, 47, my lord, I'm so sorry.
47, that's my fault.
47, tab 8, page 264 of the authorities bundle.
Thank you.
Fifthly, flows on from that, there will inevitably have been, or almost inevitably have been, a situation in which there were acquaintances with individuals and companies in the market, and perhaps equally inevitably, if the past performance and past experience went well, the forming of friendships or personal acquaintances of those that they had been working alongside. And the judge appeared to accept that, at least appeared to accept that in paragraph 146 of the judgment, which we submit is correct so far as it goes. But there's nothing wrong or invidious about that. There are many situations in which acquaintances or friendships will have developed in that way. That does not indicate a closed mind. It would not indicate to the informed observer that the judgment or decision making of about who was best suited to this urgent and emergency role, that the waters were polluted in that sense. There's nothing illegitimate about bringing to a decision a view about the service provider with whom you've worked. Service in the past excellent, a good experience of working with them, ability to trust them based on past experience, and friendships as a perfectly legitimate concomitant of that. The difficulty flows thereafter, and the sixth submission is that we do respectfully submit that the judge was in error in concluding that there was a need to avoid, in order to avoid the appearance of bias, for the defendant to do the two things that I summarised earlier. In particular, I'll deal with this as my sixth point, to consider other agencies. Her findings are summarised, I hope, helpfully in our skeleton at paragraph 23 in that respect. And I wanted under that sixth submission, if it doesn't give you too many sub-numbers, to make 4 or 5 short points in support of it.
This is in relation to the submission that it was wrong to find that other agencies should have been considered.
Exactly so.
Right.
When she uses the word considered, what is meant? Is it to consider it in the way that she identifies in the preceding paragraph?
I think that must be it.
That was why I raised the question I did. So it's not just think of or subconsciously know about, because
they
the
did
people
that.
we're talking about self-evidently knew about everybody in the market.
Yeah.
So she must have meant...
She must have meant something more formal with objective criteria,
Right.
and why you're doing it this way, and is there a
Because the
comparative
evidence
process?
does not bear out a finding on any view that there was no consideration in the looser sense that I perhaps wrongly had in mind to start with.
That's why I drew your attention
Yes,
to those
so
5 findings.
it's a substantial, a formal process with a small f.
I'm going to call that a comparative process for the sake of argument,
Yes.
or just for the sake of shorthand, in order to identify those more formalistic elements. You're right to draw that out, and that's why I drew your attention to those paragraphs. So the 4 or 5 submissions in relation to that. Firstly, we respectfully do submit that there is no springboard based on personal acquaintance derived from past working to this set of additional requirements, this set of additional comparative processes. I mean, what she appears to have said, which is why I said that 146 is accepted or correct as far as it goes, is what she appears to have said is, well, there's nothing wrong with having personal relationships. That doesn't itself found a case of apparent bias. But nevertheless, in effect, it's like a presumption, as it were. It creates some sort of presumptive problem, which then triggers the need for this alternative process. And that's what I mean by springboard, and we respectfully submit that isn't the right approach. There isn't any springboard at all. It's a normal and accepted part of the Reg 24 procurement processes of this type in a narrow market of the kind involved. And there's nothing to suggest that such a relationship, based on past working and the acquaintance that is derived from that, or is the concomitant of that, there's nothing to suggest that such a relationship creates any such presumption of bias or presumption of an unattractive appearance that then needs to be met by the further processes that she identified. That's the first point. So the leaping off point is not well founded. Secondly, none of this, and by none of this I mean none of the two things as we've explored them at Shorthand, none of the two things is required by the scheme of control in the combination of Reg 24 and Reg 32. Urgency, which was accepted at paragraph 99 of the judgment and in the findings specifically made under Reg 32, which we submit are correct, urgency justified not adopting a comparative approach, and the sort of comparative approach that would be inherent in the ordinary procurement processes.
I mean, she deals with this, doesn't she, at para 164, where she says she recognises the urgency. It says that did not exonerate you from conducting procurement.
That's true. But what she appears to envisage is some form of procurement process light. That's a terrible phrase, and light is probably spelt wrong in it. But there's nothing, I respectfully submit, in the scheme of the regulations that suggests that. What she appears to say is if you've got something which might give rise to some form of presumption, we say there isn't anything that gives rise to that, but her reasoning appears to be if there is something that gives rise to that, you then need to do something a bit like you need to do something a bit like the ordinary processes, including objective criteria, a formal comparative consideration, see para 168, contacting them to check availability or capacity. So a pretty onerous process. When I say it's the ordinary procurement process is light, it's not that light. But there's nothing to suggest in the scheme of the regulations, which do specifically deal with urgency, there's nothing to suggest that you need anything of that kind. So
that comes to, sorry to interrupt you.
I'm so sorry.
Putting it in very simple terms, that comes to the point that essentially your submission is that there's an irreconcilable tension between 124 and 164. 124, where she makes findings that this is an urgent regulation 32 case, and 164, where she then says that that didn't exonerate you from doing what you call procurement light, but perhaps not that light.
Yes. Yeah. It's that basic point I made earlier on about, you can call it robbing Peter to pay Paul, or left hand and then right hand. It's that point, based on 32.2c in particular. That's the second point. With its more fundamental overarching point, which is that there's nothing in the scheme of the regulations to suggest that anything of this kind is necessary. What she's effectively done is to wrongly identify that there is a springboard, I respectfully submit, and then say, well, in the light of that, I can, as it were, magpie bits of the ordinary procurement processes, and they need to be brought in for the purpose of dispelling the presumption of bias, which I say has been created, or she says has been created. That's the second of the sub-points. The third is that it is clear on the evidence that those who made the decisions on public first, because in a small market they were in place and known to and trusted by those making the decisions, and they were selected because the decision makers knew or believed that they could deliver in a real life-threatening emergency. And it goes back to the point that my lady was putting to me, some care with the findings, possibly based on the meaning of consider, because it isn't the case that, for example, Mr Cummings did not know the other players in the market, did not know about the market, and did not know who else might or might not have been around. That's clear from that's absolutely patently clear from both from his evidence and from the other evidence in the case, including from Catherine Hunt. So that's the third point. The fourth point is that the judge does make a series of findings to which I drew attention I hope fairly, at paragraphs 158 to 163. And the global answer that we give to those findings is that an informed observer would understand that there is an emergency or urgency process built into the scheme which obviates the need to do the comparative exercise as between different potential bidders who might or might not be available. And would also understand, we submit, that there is no point in taking precursor steps. Who is available? Who might have the expertise? Who might be around? If you don't have to do the comparative exercise at the end. The informed observer would hardly hold it against you if you did not prepare to do that which you're not required to do. So, for example, there was no need to identify the objective criteria to enable that comparative exercise to be done, the finding at 159. It's simply not necessary to do that in order to dispel any issue that might arise as a result of personal acquaintance with the person awarded the contract. In relation to paragraph 160 of the judgment, no one undertook any assessment to determine whether Public First was the most appropriate agency to use. Mr Cummings, Mr Aitken didn't consider the possibility of using an alternative agency. Well, so far as that is concerned, I'm not going to go back through all the evidence, but again, one needs to be a little careful. Mr Cummings says that he wanted to use Public First for the reasons given in his witness statement at paragraph 8. I don't invite you to turn it up, it's in supplemental bundle tab 8, page 128. But he says in essence that he knew from his experience that Public First was very good, as he puts it, at running focus groups. Key staff had thought extensively about how people who usually ignore most news and political communication might be influenced, knew he could rely on them to make an extra effort beyond what they were paid to do, knew they would give him honest information, unlike many of the companies in this sector, says he perhaps controversially. Very few companies, again, equally controversial, he says, in this field are competent. Almost none are very competent, honest and reliable. So there are a series of reasons for the preference for doing that, and that evidence was added to by Alex Aiken's evidence, indicating that his primary reason for choosing Public First was that they were already on the ground and continuity at that time was critical. See paragraphs 44, 47, 51 to 53, 55 and 57, and all of those are in supplemental bundle tab 7, pages 115 to 118.
I mean, again, we've got the use of the word considered, because in a sense, if one reads the witness statements, there was consideration, albeit in the negative.
Yes. Well, both in a negative and in a positive.
There was a comparative thought process in that loose sense, but again here, the judge seems to be using the word considered as meaning something more formal.
It appears so.
Considered in the sense of pursuing, if that makes any sense.
My lady, that does appear to be so.
It can't be right on the undisputed evidence. There was no consideration in loose terms as part of the natural thought process. Why are we doing this? Well, because.
But there's a positive and a negative aspect, but I rather agree. She appears, that's why I said she appears to be envisaging some form of formalised process which goes at least a considerable way towards replicating that which you don't have to do positively if you fall within 32(2)(c). Then in 161, failed to use the RMDPS to identify potential suppliers, and that wasn't used. But that is dealt with and answered in terms of timing by Alex Aiken again. See paragraph 19 of his statement. He says it normally takes 6 to 8 weeks to do that, and that was simply impractical in the circumstances. That's 161. 162. You can read for yourself the issues that are raised there by the judge. And the only submission we make about that point is that, aside from the overarching answer that I gave at the beginning, is that, as Miss Hunt explains, the reason that Public First was in a better position to provide the services was not because it was better able to be briefed, but rather because it already had focus groups on the ground. See paragraph 19 sub A of her second witness statement, supplemental bundle tab 13, page 232. And that paragraph in its totality, both A, B and C of paragraph 19, same reference, is also key in terms of the answer to, or at least a context for, the finding by the judge at 163, no evidence to support Miss Hunt's view that no other agency would have been able to meet the defendant's needs. In that paragraph, in its three subparagraphs A, B and C, Miss Hunt explains precisely why other agencies would not have been able to meet the defendant's needs. And again, I'm not going to go formalistic about all of this, but this was evidence, in effect, in a judicial review provided by the defendant, no cross-examination, and those reasons are set out relatively clearly in that paragraph. Miss Hunt's evidence is also important in relation to the other bit of 163, which deals with jigsaw. And again, I don't want to go into great detail about this, but can I just refer you to the following bits of evidence that go to jigsaw. First of all, Miss Hunt, second witness statement, paragraph 20, sub B, tab 13 again of the supplemental bundle, page 234, where she says, based on our experience of working with jigsaw, my view is that it would not have been able to set up and report on focus groups as urgently as was required, particularly where Public First were already working with the Cabinet Office and had groups set up. This view was borne out by our later experience of moving to virtual focus groups, and so on. And then in her first witness statement, she points out at paragraph 62, tab 9 of the supplemental bundle, page 154, that Jigsaw did not have the policy experience to carry out this work, which was both about developing policies and measures to address the rising COVID infection rate and effective communication to drive unprecedented behaviour across the entire country. And there was obviously an immediate requirement for that. 163, finally, the judge finding, Miss Hunt suggests that YouGov did not have the experience to do work at the scale or pace required, but the agency was not approached to ascertain whether it could meet the defendant's requirements. True it is that they were not approached, but again, that needs to be placed into context, and see for the context Miss Hunt's evidence, if you would, tab 9, page 155, and also, that's in her first statement, and also in her second statement, paragraph 20, sub F, tab 13, page 234. So we do submit that the specific findings made by the judge do need to be placed in the context, or into the context of the evidence, but ultimately we respectfully agree with the exploration that my lady engendered, which is that she appears to have approached this on the basis of a pretty formal and a pretty onerous conception of consider, which drags in really pretty significant parts of the procedure which the regulations actively do not require in an emergency. The final sub-submission under this sixth point is this. we do submit that the judge was not justified in the circumstances in assuming or finding that the informed observer, if that's the test, would infer from the fact that these precursor steps either were not taken or may not have been taken, particularly when you produce the wraparound context of the evidence, that there must have been, or that there was a real risk that the contract was awarded for personal reasons. And that's a necessary part of the reasoning if it's to work. Personal reasons rather than say because everyone concluded that they were best at their job, there was an emergency to hand, and even if there were other things that could have been done, non sequitur, that properly could support an inference in the mind of the reasonable observer or the informed observer, that it follows therefore that the presumption which the judge found to flow from personal acquaintance must have been the reason for the contract award. So there's a real disconnect, we submit, between those findings that you might have been able to consider others more carefully or in more detail, even assuming that finding is well made, and bias. So that's the sixth submission. The seventh and final submission is a respectful submission that the judge was also in error, that there was a need to avoid, in order to avoid the appearance of bias, for the defendant to produce some contemporaneous record of the objective criteria used to select public first over other research agencies. And I mean, all of the points I've just made under the sixth submission are irrelevant here too. But it is, we respectfully submit, very hard to see how a fair-minded observer would insist on some form of, as it were, contemporaneous record as part of considering whether bias existed. The key question is whether urgency and the emergency that was facing the country in those days justified the application of Regulation 32, I respectfully submit. And there are explanations for the award. There are justifications for awarding it to public first. They are extensively set out in the evidence. So this is in effect a requirement introduced through apparent bias, which effectively says that the presumption of bias flowing from personal acquaintance will not be displaced unless there is a contemporaneous record. Brackets, even if the explanations given in the witness statements are accepted.
In that context, can I ask you about paragraph 141 of the judgment, where the judge seems to have, relied on this, doesn't she? View that the decision maker cannot meet a claim of apparent bias simply by giving evidence, either detailing what was in his or her mind at the time, or asserting that she was not biased. Now, certainly Porter and McGill and Georgiou provide authority for the proposition that you don't take assertion into account.
Yeah.
Is her statement of the law earlier in relation to the evidence, subsequent evidence of detailing what is in your mind, is that an accurate statement of law?
Well, my lady, it's a bit of a fraught area, and she returns to it in relation, I think, in fairness to her, to the statement by Mr Cummings that says, of course I didn't.
Yes.
Do it on that basis. The case law, as I understand it, at least in relation to judges, is that you never go and say,
this is what I was thinking.
this is what I was thinking.
Or I had an open mind. But
or I had an open mind. But what you do is what you do and you can do. Sorry to interrupt. Is to produce the reasons for your decision.
And can they be taken into account properly by
My lady, my respectful submission is they must be, because otherwise you'd be in a slightly strange position under these regulations, where you're required to justify your action under Regulation 32, but the explanation that you give for that must be regarded as irrelevant. even though it goes to the adequacy or otherwise, or the good sense or otherwise, of your awarding the contract to a particular individual, they have to then be ignored in some way when you come to the appearances of bias. That can't be right.
So on this point, the timing point is critical, isn't it? Because effectively this comes to the no contemporaneous note.
Yes.
If you're right and here's all the evidence, 6 months later, whatever, if that's a justification, then it does come to
Contemporaneous or not.
contemporaneous or not.
Which can't be right.
It
You can't turn on that.
Yeah.
Well, potentially, I'm just throwing it out there. But at some stage, I personally would like just to some reassurance or otherwise as to the accuracy of that statement, simply by giving evidence, either detailing what was in his or her mind at the time he or she took the impugned decision. Just not sure that that's...
Well, my lady,
Whenever's
I'll
convenient.
check back to the citations
Thank
again
you.
just to make sure about that. But even if something like that is said in the cases which she cites, it would be little short of amazing, I respectfully submit, if that was anything other. They were anything other than context-specific statements to do with the facts of those individual cases.
Well, I couldn't find that statement.
Well, in which case.
No, but I didn't look at there are underlying cases referred to as well, so it just...
But my respectful submission is there's nothing wrong with a public authority decision maker explaining the reasons for their decision. Maybe as simple as that. And if that is so, then it's impossible to see why those things cannot and should not properly provide the true context in which the apparent bias issues fall to be judged. And that, of course, is different from a situation in which a judge or anyone else turns up and says, I didn't have a closed mind or I didn't think about that. That's a different thing.
Well, the point there is that you can't come along and say, well, I wasn't actually biased.
You can't conclusively solve the legal issue by statement.
Bare assertion.
I agree with that. But I'll double check that.
Thank you.
My lords, my ladies, those were the submissions I wanted to make in opening the appeal. Sorry, I've gone a little bit over, but not by much.
Well, I suspect that was our fault. But thank you very much, Sir James. Great. Yes, Mr. Copple.
Thank you, my lord, my lady. We say in relation to apparent bias that the judge was entitled to reach the conclusion that she did in the light of the factual findings which she made and which cannot now be challenged. I'm just pausing there on the factual findings. You've heard a great deal from Sir James this morning, inviting you to look back at the defendant's evidence before the judge, for example, in the statements of Ms. Hunt. This was evidence which the judge did not accept on the facts. And had this...
Well, is that what she said?
Well, Lord, I'm going to
basis?
take you. I'm going to take you through her factual
Yes,
findings, but she has made factual findings which are not open to challenge, and no attempt was made to challenge them in the original notice of appeal. And had that been done, the outcome may well, certainly the terms of the permission may well have been different. She correctly stated the law on apparent bias in our submission between paragraphs 135 to 141. And I note the point which my lady has just made.
Thank you.
On that, and we'll come back to
Thank you
that
very much.
as well. But subject only to that point, there's no challenge to her statement of the legal principles, 135 to 141. She did not, we submit, misdirect herself in the sense of taking into account irrelevant matters or leaving any relevant matter out of account. And she reached an evaluative judgment which was open to her to reach. as to the likely perception of the fair-minded and informed observer of the facts that she had found. And on that point that you are concerned with a review of an evaluative process of reasoning by the judge, we've referred in our skeleton at paragraph 45 to a House of Lords case called Davidson and Scottish Ministers. I won't go to it now, but it's a judgment of Lord Bingham, which you'll find at paragraph 17 on page 273 of the authorities bundle, making the very point on the facts of that case that he would not overturn an evaluative judgment of the Court of Session in the absence of the sort of mistake which this court is well used to seeking out on an appeal. Now, we say that the judge's findings were open to her, but we go further in paragraph 46 of our skeleton argument, and we say that she reached a decision which was plainly correct on the facts. We say this was a clear and obvious case of apparent bias. Now, I'm going to make 5...
And just so I'm absolutely clear what you're saying about this, in the grounds, I think you say that this is apparent bias in favour of the company that got the contract. Yes. So that's how you put it.
Yes.
So not against anybody, just in favour of public first.
Well, my lady,
What does that mean,
follows...
bias in favour? Yes, well, it follows it's against others.
Yes, it follows that because it was in favour of public first, it was against anybody else.
Or who?
Who?
Well, we've got evidence, haven't we, which the judge quotes,
yes.
I think.
So we have some evidence and we have some findings by the judge that there were other providers who were capable of doing the work which was given to public first.
I don't think that anything goes that far in terms of timing, value, capacity. But we've got some high-level comments about perhaps Jigsaw having. I may have missed it. Is there a finding that anybody else was actually in a position to deliver? Anybody suitable was in a position to deliver the next day or that evening?
Yes. So, well, first of all, my lady, the issue isn't simply whether somebody was able to deliver that evening.
No, I understand.
Because it wasn't simply that evening that the contract covered. It was that evening, and then the decision was made that Public First should carry on throughout March and then indeed all the way through to September. The finding...
But where is the finding
so 163...
Who's been prejudiced?
So 163, the judge rejects Ms Hunt's view that no other agency would have been able to meet the defendant's needs. And
She doesn't reject it. She says there's no evidence to support it, and she refers to Jigsaw and YouGov.
Well, lady, she doesn't accept it. We say she rejects it. What happened in the sketch of the evidence below, lady, is that it was acknowledged that this is a small market, but a market in which there are 80, 90, 100, 120 companies on the dynamic purchasing system, which you see referred to in 161. Some very large companies, some very respected companies, and we had a large amount of evidence from the defendant trying to argue that nobody else in the entire market was capable of providing focus group services in March of 2020 to meet their needs. And it was unsurprising that the judge didn't accept that, and she gave some examples. She gave the example of Jigsaw, she gave the example of YouGov. Now those are two important examples because those were agencies with whom the government already had a contract. Didn't even need to.
In paragraph 156, she quotes Miss Hunt's view as, in my view, only 2 companies in the market had the scale and expertise to provide these services in March 2020, Public First and Britain Thinks.
Yes. Yes. And that is the view which the judge refers to in the first line of 163. There is no evidence to support that view. And, my Lord, in a market of that size, that is unsurprising, in particular in circumstances where the government already had contracts.
Do we need to have a look at the circumstance in judicial review proceedings in which the evidence of the respondent can be rejected when it's not challenged and not cross-examined?
Well, my Lord, we don't, and the reason is that what Ms Hunt was doing was expressing a view which hadn't been thought about at the time. She was expressing, and again, you heard some submissions by Sir James about this. It is well established in public law that the court will look less favourably upon ex post facto explanations. And all of this view of Ms Hunt was an ex post facto. We don't think that anybody else would have been able to do it, but it was never considered at the time. And that's a finding of fact as well in paragraph 160. Paragraph 160, neither Mr Cummings nor Mr Aiken considered the possibility of using an alternative agency. So this is a classic ex post facto justification, and the judge simply did not accept that that had been the view, that had been the considerations of the decision maker at the time, and she was well entitled to say, well, as a view, as an ex post facto view, it's simply not supported on the evidence.
Was there any evidence before the court from any of the other players in the market?
So there wasn't evidence from an individual company, but there was indirect evidence given through my instructing solicitors and given through Lord Wood of Anfield, who also gave a statement about the wide range of companies which do this kind of work. And then there was evidence that Jigsaw and YouGov had existing contracts to do the very kind of work which was then given to Public First. So, apparent bias in favour of Public First against other potential service providers, of which there were some. So I hope that answers my Lord's question. There was then, as I noted earlier, a vigorous argument about whether the claimant, as a non-governmental organisation, should be permitted to seek to enforce the law of apparent bias, and it was argued that the claimant didn't have standing, and that was rejected. My Lord mentioned in your opening comments to my learned friend that no provider challenged the award of this contract. I think you said that they were that you said only one other provider could have done the job. They were well aware that the contract.
Yes, well, that was quoting Miss Hunt's evidence. Yes,
indeed, and they weren't concerned. But Lord, those matters were considered by the judge on the standing issue, because of course one of the reasons why she found in favour of the claimant on standing is that this was a case in which it was necessary for judicial review to be available, because one simply couldn't expect a disappointed bidder or potential bidder to bring a claim under the regulations. Why couldn't you expect it? Well, because by the time that the government published the contract, late in June of 2020, it had more or less expired, or certainly the vast majority of the work had already been done under it, and there was no incentive for any economic operator to come along and bring a challenge. That was one of the reasons which the judge relied upon in finding that the claimant and public law should be permitted to bring a challenge. That's paragraph 180 of the
Paragraph 180 doesn't say that. Paragraph 180 says there wasn't a competition, so there wasn't a disgruntled bidder.
Well,
there's no timing point there.
Well, perhaps I'm confusing what the judge said with what we submitted to
Yes,
to her.
I'm going on what the judge said, which is there was no disgruntled bidder.
Yeah. Well,
I mean, she's explaining as to why that is unsurprising in these circumstances.
yes, and it's perhaps it's the words, there is no disgruntled bidder who could be expected to challenge perceived failings in the procurement process that were sufficiently serious potentially to affect the outcome. Why couldn't it be expected? Well,
I hurdle, establish financial loss.
Unlikely to risk legal costs. So there was argument as to whether public law should be available. Answer, it should for these reasons. And the claimant was well placed, see the previous paragraph, 179, to bring that sort of challenge. And this wouldn't be the first case, like there's a question my lord also raised, this wouldn't be the first case in which a party who was not the contracting party had brought a judicial review challenge to the award of a contract. We haven't cited the cases that we didn't realise the point was an issue. But there are cases where, for example, a trade union has
I'm well aware of that. It was relying on apparent bias that had an impact on other identifiable people, if it had an impact at all. And that's what I've been unable to find. Not. I mean, Chandler is a good example of a case where there was a claim brought.
Yes, yes, and I'll come to apparent bias in a moment. But we say in short, there's no reason why apparent bias should be excluded as a ground of public law challenge in this context, when other grounds of public law challenge are available. See the ruling on standing, and in particular where Regulation 24 requires that there be domestic law which prohibits both actual and apparent bias in the conduct of a tender process. So, 5 points as to why we say the judge reached a decision which was...
I'm so sorry, I'm just before you move from that point, prohibits apparent bias, the Regulation 24 you submit. So
Yes.
and I appreciate that there's been some consideration of this judicially. Have you got an authority for that?
So that's the authority of EWHC, which we have summarised in our skeleton argument at paragraph 30, and which you will find in the authorities bundle, I'm sorry, at tab 20. And on the particular issue of apparent bias, it's 43 to 45 on page 610. And
but that just repeats Regulation 24 insofar as it says that it's necessary to take appropriate measures to prevent and detect and remedy conflicts of interests. I mean, I understand you can say the objective is, but it doesn't use the word prohibit, does it? Or
yes, so in terms of prohibit, the starting point is as my lady says, Regulation 24, and what authorities are required to do, and what member states were required to do by Article 24 of the directive, was to require their authorities to take appropriate measures to prevent, identify and remedy conflicts of interest. Now, it doesn't say conflicts of interest are prohibited, but the reason why contracting authorities must take measures to prevent, identify and remedy conflicts of interest is because they are prohibited in a tender process, because C. E. Vigilo, they call into question whether the authority has complied with the general principles of equality and equal treatment. And paragraph 43 on 610 that I was referring to is the finding of the Court of Justice that it would be incompatible for the burden to be placed on the applicant to prove that the contracting authority was in fact biased, was actually biased. And the rule that the conflicts of interest with which Reg 24 is concerned extends both to actual and apparent bias, as is clear from that paragraph. That is reflected in the wording of the regulation itself, and Sir James took you to it, I think, earlier on.
Would that have the effect of, by operation of law, prohibiting some public procurers from contracting with some people with whom they had connections that give rise to apparent bias? I mean, take your case was a very straightforward one, as I understand it below. It didn't depend upon the subtleties of the approach of the judge. I mean, your primary argument was that Mr. Cummings' connections with the company were sufficient to give rise to a perception of apparent bias. Full stop. The judge rejected that. But if that were right, then it would effectively bang out of the market, and a tight market as we know here, some suppliers, and apparently achieve the precise opposite of what the regulation is, these regulations are supposed to do, which is fair competition.
Yes. So well, that isn't what we say. That's not right. That the effect of Regulation 24 could be to entirely prohibit contracting with a particular entity. What would usually happen if this was a procurement case, a standard procurement case where there was a tender evaluation, is that the authority would be expected to choose its evaluators in such a way that either they didn't include somebody who had a personal friendship with one of the bidders, or if they did include that person, that there were safeguards surrounding what they did. So, for example, they weren't the only evaluator.
Yeah, but wasn't your point that even though Mr. Cummings didn't make this contract, he didn't actually decide in the end that his influence was such that it was irresistible. That was, in a sense, what you were arguing. Now, put apparent bias in a different context. If we as a court of appeal were hearing an appeal where one of the parties was one of our close family members, there's nothing we could do, save waiver by the other party. There's nothing we could do to put in place safeguards, because that's precisely what you can't do. So I am a little puzzled by this, Mr. Coulson.
Well, my lord, the safeguard would be to have a different judge, as in, and just as the safeguard in the example I gave would be to have a different evaluator.
Yes. But that would then mean, in the context of procurement, that the very person who has to deal with the outcome can't be involved in the process. What you're saying is Mr. Cummings shouldn't have had any involvement in this at all.
No, that's not what we say, my lord. The facts of the case are extreme. He was the decision maker. Nobody else called into question scrutinised his decision. And there were no safeguards surrounding requirements to consider alternatives, for example, whatsoever in the decision-making process. He simply decided to appoint public first without considering anybody else. See paragraph 160, second sentence. And Mr. Aiken's role was to sign that off as a civil servant. But Mr. Cummings is perfectly clear in paragraph 17 of his witness statement on page 131 of the supplementary bundle that he was the decision maker. Perhaps I'll take you to that.
So it's not paragraph 17.
I'm sorry,
It must be another one. Don't worry. I think it must be. This calls for my recollection, which is at odds with yours.
Yes, it's
paragraph 20. I'm a special advisor. I'm not allowed to direct civil servants. But as a result of my suggestion, I expected people to hire public first.
Yes, it's paragraph 14 at the top of 131. I'm sorry.
No, don't worry.
Don't worry, let's
find it.
Let's just get this straight. Could I have the page number again?
131.
Yes.
And it's the I was the driving decision maker on this. You can go back to the previous page to see.
Yes. Thank you.
What. Now, my lord, this is certainly part of the defendant's case to say, well, our hands will be tied, and this is completely unreasonable to expect safeguards to be in place. I'm going to take you in a moment to the Boardman report, which is now government policy, which says precisely that safeguards should be in place.
Yes.
And we'll see in due course what those will be, and not that you simply won't be able to contract with certain people. That's simply not the position, either under Reg 24 or under the common law, or as a matter of what is now the defendant's own policy. So, we say this was a clear and obvious case of apparent bias, and we make 5 points, some of which I've traversed already. Firstly, this was a decision made by Mr. Cummings. And there is nothing in Mr. Aiken's statement to contradict Mr. Cummings' account that he decided that public first should be hired and that he expected the civil service to action it. Second point, there were personal friendships as well as close professional relationships between Mr Cummings, the directors of Public First, and Mr Gove, the defendant, as the judge found in paragraph 145 and 147. And we say that there can be no serious challenge to the judge's starting point that personal connections, in particular personal friendships of this nature, are a factor which the fair-minded and informed observer may perceive as compromising the impartiality of the decision-maker. That's Mr Cummings, when he decided to give the work to Public First. Now, you've been invited to look at the Lewis case for an exposition of the principles of apparent bias in the context of alleged predetermination by a planning committee or a councillor involved in a planning committee. But it is well established that a local councillor, for example, may, for party political reasons, have a legitimate predisposition towards a particular policy or decision. That sort of predisposition is well recognised and is not offensive. But a person deciding on the award of an 800,000 odd contract is not permitted to have a predisposition towards a certain service provider as a result of a personal friendship or previous close connection. That's not the case either in the procurement context, or indeed in the local authority context. And there's plenty of case law to say that a councillor sitting on a planning committee is not allowed to be predisposed because of friendship towards the beneficiary of the decision. We cited one of the cases, it's in the call bundle at page 147 in our skeleton argument for the hearing below. Page 147, paragraph 84, a case called Gardner and Harrogate, on a social relationship, a friendship between a member of a planning committee and the beneficiary of a planning decision. Now, the judge's starting point is clear, 146, 147, 168. These friendships did not preclude impartiality on Mr Cummings' part, but they raised a concern about impartiality, would raise a concern about impartiality in the mind of the informed observer, which was not allayed and indeed was heightened then by the manner in which and the basis on which the decisions were taken. So it's not simply friendship. Friendships raise the initial concern, and then she goes on to look. So that's it, in particular 147, first sentence. And we say that is...
So 146 first...
147, first sentence.
Yes, I'm just looking, if we can go back to 146, because your submission was that knowing, being friends didn't preclude impartiality. Now, that's looking at actual bias rather than apparent bias. So the judge at 146, sentence 1, the fact that the individuals were known to and had worked with those involved in the decision-making, including the defendant and Mr Cummings, is insufficient to establish apparent bias. So the connections are not sufficient.
Not in and of themselves.
And we can scoop up personal friendships in there, because that comes in the next sentence as all part of the same conclusion.
Yes. But then at 147, they, first sentence, existence of personal connections, including friendships, was a relevant circumstance that might be perceived to compromise impartiality and independence in the context of a public procurement. So one then looks at other circumstances to see whether that potential concern was allayed or exacerbated. And
There seems possibly to be a contradiction between the clear finding in para 146 and then the statement in 147.
well,
Because isn't that perceiving to compromise impartiality is shorthand for apparent bias, isn't it?
well, my Lord,
I mean, I'm just
What the
puzzled
judge-
by it, that's all.
what the judge is saying is that the personal relationships are not in and of themselves disqualifying because of the in the sense that they give rise to apparent bias, but just as under Regulation 24, just as under as we'll see from the Boardman report in a moment, what personal friendships do is they raise a concern about impartiality in the mind of the observer, and then one looks at the way in which the decision was taken in order to ascertain whether that concern was allayed or not. And there isn't in our submission any contradiction between 146 and 147. It's simply saying it's not enough in and of itself, not conclusive, but it does raise a concern which one then has to take forward in examining the process that was adopted.
Is there any authority for that approach?
Well, my Lord, there's authority in the sense of Regulation 24, which requires conflicts of interest to be identified and remedied.
No, the approach that says, well, there's a relationship. Relationship of itself doesn't give rise to apparent bias, but it creates some sort of heightened sensibility. I think Sir James put it as a presumption, that may be overstating it, but it's that sort of area. And so you have to do all of these other things as well. And I just wondered if there was any authority, given that we're concerned with apparent bias, which is obviously a serious allegation, whether there was any authority in support of that approach. I'm not aware of any, and I don't think there's any in the authorities bundle, but I may have missed it.
Well, what the authority is the well-established approach of considering all of the circumstances. Now, all the judge is doing here is saying, here's one relevant circumstance, personal friendships between Mr. Cummings and public first, amongst others. There are other circumstances which then need to be considered in order to decide whether that initial factor, that initial concern, can be taken forward to finding of apparent bias.
It would make more sense, maybe the wrong way of putting it, but if the learned judge had found it did create a conflict, the personal relationships and the working relationships created a conflict, those could have been allayed by the taking of certain steps, but they weren't. But here, the judge has said there wasn't a conflict of interest. There might have been, or perhaps, but there needed to be more done in order to make sure there was no apparent bias, because there was a bit of a potential for concern. Do you see what I mean? It would have been, you could see it working the first way. It's more difficult the other way, is it?
Well, the first way is precisely what the judge says in paragraph 147. that is precisely her reasoning process. Personal connections was a relevant circumstance that might be perceived, but then one has to go on to see what else was done.
But I thought it's what the fair-minded and informed observer would conclude, not might conclude.
Well, yes, so what she's saying is the fair-minded and informed observer looks at the situation and says, well, I do have a concern that Mr Cummings, who is friends with this organisation, is simply deciding to give them a contract without considering anybody else. But of course, being a fair-minded and informed observer, I need to look at how the process was operated, and there may well have been other factors which allay the initial concern. And that is absolutely standard in the procurement context, whereas as you've heard from Sir James, it is common for there to be knowledge of the players in the market, but there are then safeguards because knowledge of the players in the market is not a permitted basis on which to award a contract, and certainly friendship with the players in the market is not either. So
I think my lady's point is really this, that in almost all circumstances where apparent bias is alleged, when judicially, quasi-judicial, so on, licence applications, planning applications, the starting point is there's a connection of some sort, and that gives rise to apparent bias. Now, the whole point of the fair-minded but informed observer is to cater for the fact that when you know a little bit more about it, it dispels the starting point, which is a suggestion of apparent bias. So the classic, if you remember the early authorities on this before medicaments, dealing with the fact that a judge may have a former member of her chambers or a former pupil in arguing a case. Some litigants were saying that doesn't seem right. There's a connection, therefore apparent bias. The courts say, well, no, because once you know how the profession works and professional relationships, no fair-minded and then informed observer could come to that conclusion. So I think my lady's point is that whether it's right, it's just a question, is that the judge seems to have got it back to front here.
And my answer is that the judge has proceeded in precisely the way that my lady said would be acceptable and which you've just put to me. And that's consistent with both 146 and 147. 146, the first sentence, the connections are insufficient to establish apparent bias. So the claimant's claim is not made out simply because of the connections, but that is a starting point. That is a concern. See 147, and one then needs to delve a little bit deeper and see how the process was operated. That is in my submission an orthodox and approach, and indeed the one that my lord has just put to me.
And would that lead into the normal? Again, it's just because apparent bias is arising in such an unusual context. The suggestion, if apparent bias is alleged against a decision maker, let's say in a contested planning application or a contested license application, if the decision maker were assiduously to record all of his or her thought processes along the way to making the decision, that wouldn't save an apparent bias argument, or would it?
Well, it may do, my lord. And there's an example of that in the Condron case, which you have in the bundle, where there was a concern raised by a conversation which a member of a committee had with a protester the day before the committee sat, and the Court of Appeal said that concern should have been allayed by the deliberations at the meeting, at the actual meeting, which showed that there was detailed consideration given to this, that, and the other, and no question of predisposition, looking at the way in which the decision was taken. So my lord, that is a legitimate reasoning process on the authorities as well. I won't take you to Condron, but it's tab 11 of the bundle, and you'll see what was said in that case. Now, my learned friend referred you to the case of Pratt, Privy Council case of Pratt, as he had referred the learned judge.
Sorry, Mr. Cobble, sorry to interrupt you. Just for my very pedestrian note, are you moving to the third?
I'm still on my second
You're
point
still on your second. That's fine.
about friendships being a legitimate starting point for apparent bias.
Yeah.
So my learned friend's submission is that, I think, and he rather expanded it from his skeleton argument today, that not just knowledge of the bidders, but also friendships with the bidders was to be expected in a procurement context, and an authority might be hobbled in its ability to award contracts if the position were otherwise. Now that is not what Pratt says. You have it in the bundle at tab 8.
Yes.
Page 253. It is a breach of contract case. The first point is not a public law case. And there is an allegation of breach of an implied tender contract due to the treatment of the claimant's tender. You'll see in paragraph 2 on page 255 what the contract was, and it included an implied duty to act fairly and in good faith. And if one then goes to paragraph 47, in Lord Hoffman's judgment, you see he quotes he quotes in paragraph 46 from another case which had been adopted in the Court of Appeal in Pratt, and he says the judge's findings of apparent bias were therefore no ground for holding transit to have been in breach of contract. So the point was that the implied contract didn't bring in all public law grounds of challenge. So apparent bias was simply irrelevant to the case. And Lord Hoffman then goes on to say a few lines below that, he says, nor did the duty of fairness, about halfway down the page, nor did the duty of fairness mean that transit were obliged to appoint people who came to the task without any views about the tenderers, whether favourable or adverse. It would have been impossible to have a tender evaluation team competent to perform its function unless it consisted of people with enough experience to have already formed opinions about the merits and demerits of roading contractors. Now, 2 points to make about that. Firstly, this is not a case about friendships. This does not say it is acceptable and there could be no complaint of, or there will be any difficulty with a rule that a tender team should not have close friendships with the bidders. It's about knowledge of the market and pre-formed opinions about the merits and demerits of the bidders. But, my Lord, even that doesn't read across to domestic procurement law. I think we provided you with a couple of additional provisions from the regulations yesterday, one of which was Regulation 67, which deals with contract award criteria. Yes. Contracting authorities shall base the award of contracts on the most economically advantageous tender. That tender should be identified on the basis of price or cost. And may include the best price quality ratio, shall be assessed on the basis of criteria such as qualitative, environmental and or social aspects.
I'm sorry, where does this go on the apparent bias argument, which we need conceptually, dealing with the apparent bias argument, to leave aside the procurement regulations for the moment, pretend they don't exist, and imagine that this was a straightforward judicial review claim by good law challenging this contract, seeking the relief that they sought, which was to quash it, or alternatively declarations and so on.
So where it's relevant is that Sir James says it's acceptable and unproblematic for decision makers in public bodies to base the award of contracts on their previous experience and pre-formed views about the bidders, and my point is simply that that is not procurement law in this country. You're supposed to have tender evaluation criteria and to mark the bids against the criteria, not to say, I know this chap, he did a good job for me last year, he can have the contract. That's not the way it works.
I don't think that's what Sir James was submitting, but
Well,
anyway.
That's
how
the...
I understood him.
There is potentially a problem with certainly bringing to bear previous knowledge of the bidder as opposed to considering what the bidder is able to offer. But well, the key point is the previous one, that this is not about personal friendships. The Pratt case is on a different issue of professional of the person who is awarding the contract having knowledge of experience of the bidders. The third point then is that the judge comprehensively rejected the defendant's factual case that Public First were the only available or even the best available agency at the time. She found in paragraph 158, I think I've made this point already, that argument by the defendant and that evidence was entirely ex post facto. 158, difficulty with that justification, that's the justification set out in 157, was that it was not part of the decision-making process at the time that the decision was taken to appoint Public First. And contrary to my learned friend's skeleton argument, this is not a matter of the defendant simply omitting to record what they thought about at the time and failing to keep a record of what their thought processes were. The judge found as a fact those were not their thought processes. They simply didn't consider anybody else. See paragraph 160. And my lady was putting to Sir James what the judge meant by consideration. Well, 160, they did not consider the possibility of using an alternative agency. So not simply they thought about who the other players were in the market, and they formed a quick view as to who was best, who was available, who could do the job. Nothing like that. They simply didn't consider anybody else, and that is a finding of fact. So I accept she does go on to talk about a more detailed form of consideration, which was not present either, and in particular in 161, 162, 163. But her first finding is there was no consideration at all of anybody else. So, no objective criteria applied to decide that public first should be appointed. That's 159. And the second sentence, the fact that public first was considered competent, reliable and honest, quoting from Mr Cummings' statement that Sir James read to you, was a necessary but not sufficient basis on which to select it above others.
Sorry, I just want to find that precise language. Which paragraph?
159, second sentence.
Thank you so much.
160, no assessment as to whether public first was the most appropriate agency, no consideration of anybody else. 161, no attempt to use the readily available dynamic purchasing system to identify whether anybody else was available to do the work. Identify in the sense of which agencies do this kind of work, who holds themselves out as doing this kind of work.
And this conclusion in 159 that you've reminded us of, the fact that public first was considered competent, reliable and honest was a necessary but not sufficient basis on which to select them above others. Is that an independent view of the judge, that for it to be lawful to select public first, there should have been a process of some sort? Or is the process only necessary because of the connections? See paragraph 147.
Yes. So all of this reasoning follows from the starting point in 147.
Yeah. So none of this, you don't submit that any of this would have been necessary but for the connections summarised in the first sentence of 147.
Well, I do have a submission that some of this is necessary under Regulation 32, which I'll come on to.
Yes, but I mean under the...
But in terms of apparent bias and the common law, no, it's on the facts of the case, it's the starting point, 146, 147, that then leads to consideration of how the decision was taken. If you didn't have the concern to start with, then the judge wouldn't have got into any of this. Wouldn't have needed to. Um, 162, no other agencies were contacted. And the judge rejects Ms. Hunt's suggestion, second sentence, that there was no time to brief another agency. And again, this is all ex post facto. Ms. Hunt comes along several months later and says, but even if we had thought about it, there wouldn't have been time to brief anybody else anyway. The judge simply doesn't accept that. Says, well, look, you briefed public first in a matter of minutes. You could have briefed someone else. Perfectly fair view for her to take of the evidence. And at 163, we have already discussed, she does not accept Ms. Hunt's ex post facto view that no other agency would have been able to meet the defendant's needs.
This is an unfair question, Mr. Coppell, but do you happen to have at the tip of your fingers the paragraph reference to Ms. Hunt's evidence on the matters addressed at 162 and 163? Where she says there was no time to brief another agency, for example.
Yes. I don't
worry.
tip my fingers, but Mr. Halliday
Thank
will.
you very much indeed. Thank you.
Will tell me in a moment. And then 164, the court recognises the pressure and the urgency of the situation, which justified derogation from the usual procedures, which can take some weeks under the PCR, but they did not exonerate the defendant from conducting the procurement so as to demonstrate a fair and impartial process of selection. The question was put to my learned friend as to whether 164 was inconsistent with 124, where the judge finds that the defendant was entitled to rely upon Reg 32(2)(c). Answer, there is no inconsistency, because C 124 Roman 3, the urgency with which Reg 32(2)(c) is concerned is it is so urgent that the time limits for a conventional public procurement could not be complied with. And a conventional public procurement, as the judge found earlier in the judgment, takes at best a few weeks. So to find that Reg 32(2)(c) is applicable, but there's sufficient urgency for it to apply, is to find that you don't have a few weeks to put a contract in place. That's not inconsistent with 164, where the judge says in the time that you had available, you could have done, more could have been done, and the fair-minded and informed observer would have been concerned that more was not done to demonstrate a fair and impartial process. So
So you don't have the few weeks under 124, you have less time.
Yes.
So you're in a worse position than you would be under Regulation 32, because you don't have the time limits in 32 because it's urgent. But because it's urgent, you have to do procurement light or whatever it is as set out by the judge.
Well, Lord, our submission, which I'll come to, is that Reg 32 doesn't preclude you from doing anything.
I'm just going again on the judge's findings and the comparison between 124 and 164. Taking your point that it means that the time limits don't apply, you've got to be quicker, then you've got to be quicker to do the things that the judge said. And so, on the face of it, that means you are in a worse position.
No, Lord, that doesn't follow in my submission. Finding in 164 is that in the time that was available to the defendant, the fair-minded and informed observer would have expected more to be done by way of process as opposed to nothing at all, which is what was in fact done. And the minimum which the judge is discussing in 164 and 168 is not an onerous matter at all. Failure to consider any other agency, 168. Not failure to hold a process, not failure to invite a bid and devise criteria and mark them and interview. Nothing like that. Failure to consider anybody else at all. So, no inconsistency, findings under Reg 32. Now, fourth point, there were other factors which were not explicitly adopted by the judge, which we say would also have been troubling to the fair-minded and informed observer, and which, if it were necessary, go to support her decision. And we've set those out in paragraph 50 of our skeleton argument, and in particular, I refer to paragraph 50, Roman 4, which is the views, the serious concerns expressed by civil servants at the time that Public First was engaged to do the work. And you have examples of those in the supplementary bundle at 285 to 286. And at 285, you have an email which is quoted earlier in the judgment, where Ms. Hunt, who is the client effectively for Public First, she's the head of insight and evaluation. She is in no doubt that Public First has been awarded the work because they are mates of Mr. Cummings and Mr. Kane.
That's actual bias,
Yes, well,
which is not your case.
no, my lord, but
That is actual bias.
my lord, and
No two ways about it. That's what that's saying.
yes, and my lord, my submission is both from, and it's 285 and it's 286. 286, where there's a discussion between Ms. Hunt and Ms. Stratton about how expensive Public First were, where the conclusion is, I thought we need to keep Public First on to deliver on people's requirements. Mr. Cummings, Mr. Kane.
Sorry, I can't quite find
286.
I've got the page, but I didn't.
Just above the Department of Health footer at the bottom. How do PF compare? I thought we need to keep PF on to deliver on people's requirements. So our submission, and the judge, I don't think understood, or I didn't properly convey what our submission was to the judge. But our submission was that the fair-minded and informed observer would have been troubled by the fact that the people internal to the defendant, important people like Ms. Hunt, the client, had very real concerns about the way in which the contract had been awarded.
But the judge didn't accept that at 167.
Yes.
He said they carried very little weight.
So we didn't, and this is my point about perhaps a slight misunderstanding of what we were saying. We didn't say, or weren't seeking to submit, that just because Ms. Hunt said it, therefore there must have been apparent bias. What we what we said is that that is a factor which would have been of concern and relevant to the perception of the fair-minded and informed observer.
Yes, but however you put it, the judge said that carried little weight.
Well, she...
Consternation expressed by other cabinet office officials, other alleged unhappiness, carries very little weight. The reasons set out above such objective assessments are irrelevant
Yes.
to the issue of apparent bias.
And the reasons set out above are those in 141. But that in our submission didn't answer the submission that we made, which is that this was simply a factor which the fair-minded and informed observer would have taken into account and would have been of concern. It's not in the same category as Mr. Cummings saying, I wasn't biased, I didn't do it because they were my friends. It's not in that category. Fifth and final point is that all of the things which the defendant puts to you today as being unreasonable and illegitimate by way of process in this case have now been adopted, or indeed had by the time of the hearing before the judge, been adopted by the defendant as policy as to what should happen in this sort of case. And that is the Boardman report, which you have in the supplemental bundle at tab 19, page 265.
Yes.
And Mr. Boardman was asked to consider the, everyone sees that from paragraphs 1 and 2, 265, to consider the facts which had been found by the department when it was investigating this judicial review claim and another similar judicial review claim. So it's this very contract which he is concerned with. He refers paragraph 11 to the findings of the National Audit Office in relation to this contract, which you also have in the supplemental bundle. He recognises the paragraph 12, the scale of the challenge, of the challenging circumstances of the pandemic. And then there's a summary of recommendations beginning at 268. And one sees paragraph 12 on 269. Commercial advice should be sought on undertaking due diligence of the supplier market in situations of extreme urgency, including wherever possible by inviting proposals, presentations from a few suppliers to establish which suppliers are best placed to provide the services and to verify that any suggested supplier is appropriate for the requirements. 15, accurate and timely record keeping is central. And conflicts of interest, about halfway down the page. 18, Cabinet Office should strengthen its model for management of actual and perceived conflicts of interest in procurement, following the identify, prevent, rectify sequence. Paragraph 22, Cabinet Office should reinforce the existing requirement that for all procurements, separate records should be kept of any actual perceived conflicts of interest and of steps taken to manage any conflicts of interest. Related to that contract. 23, the requirement to declare and record actual or perceived conflicts of interest applies to all officials or those working on behalf of the Cabinet Office, including special advisors. 25 is particularly important, where a recommendation is made for a specific supplier and no competition is to be undertaken, additional disclosure should be required. And paragraph 27, number 27, is particularly directed to this case, further consideration should be given to how to manage the additional risk of actual or perceived conflicts of interest in small and specialised sectors where there's reduced choice and prior connections are to be expected. This could include extra controls and assurance such as due diligence of the supply market, more frequent internal auditing.
Could you just remind me of the date of this?
So, 8th of December 2020. And the report goes on to explain in a little more detail why those various recommendations have been made, and I would refer in particular to 23 to 25 and 37 to 41, but I'm not going to go to those. And you have at 263 the adoption by the Cabinet Office Chief Operating Officer of Mr Boardman's recommendations on the 18th of January 2021. So all of the things that Sir James said to you, the judge was wrong to say that they might have to consider or might have to record or might have to do. They are precisely what the defendant has accepted should be done as a result of the Boardman report. And it's unsurprising in those circumstances that the judge wasn't convinced by the submissions that this was all an onerous and unreasonable requirement.
The judge had all of this.
The judge had all of that. She doesn't refer to the Boardman report in.
Well, I know, but there's a there's a bit of a similarity between some of what she said and what's in the report.
Well, I relied on the report as cogent evidence of what ought to have been done and what the fair-minded and informed observer might have expected to be done to allay the initial concern which arose out of Mr Cummings' friendship with Public First. Regulation 24, I'm not going to spend any more time on. You have the submission that it covers actual and apparent bias. The judge recognised that it covers both. She said it was primarily concerned with actual bias, but not exclusively. And there is no inconsistency, and it's no longer said that there was any inconsistency between what the judge held in relation to apparent bias and what Regulation 24 might require in any particular case, or in this case. So are the judge's findings contrary to Regulation 32, which is a different way in which the defendant puts the case? Does it cut across Regulation 32 to be required to do the sorts of things that Mr Boardman recommended ought to be done, or the sorts of things which the judge said that a fair mind would have put at rest the mind of the fair-minded observer? We say no, it doesn't cut across Regulation 32. I've made my point about what urgency means in the context of Regulation 32.
That's the time limits point.
That's you don't have enough time to conduct a procurement in accordance with the time limits in the regulations. Therefore, you can act more urgently. What Regulation 32 does not do, though, is to disapply the general rules in the regulations. So in the extracts from the regulations in the authorities bundle, tab 2, the general rules that begin at page 19 of the authority bundle in regulation 18. And the general rules continue. They include, and the last of the general rules is regulation 24 on page 21, conflict of interest. Regulation 26 on page 22, when awarding public contracts, contracting authority shall apply procedures that conform to this part. And such contracts may be awarded only if a call for competition has been published in accordance with this part, except where Regulation 32 permits contracting authorities to apply a negotiating procedure without prior publication. So what Regulation 32 exempts you from doing is advertising, is issuing your call for competition. Regulation 32 doesn't disapply, and there's nothing to suggest in 26 in Reg 26 or in Reg 32 itself. It doesn't disapply the general principles. It doesn't disapply Regulation 24. Now, the judge set out principles applicable to Regulation 32 between 84 and 93 of the judgment, and again there is no challenge to her exposition of those principles, and we rely in particular on 89, the burden being on the defendant to prove the circumstances, and derogations must be interpreted strictly. And 93, which I'll come on to in more detail in due course, even if Reg 32(2)(c) is engaged, the scope and duration of the procurement in question must be limited to what is strictly necessary. She also quotes in paragraph 84 and 85 from two sets of guidance which were issued at the start of the pandemic, one by the European Commission and one by the government. And she says in 86, although the Commission guidance and PPN, Procurement Policy Note 0120, are not part of the regulations and do not have the authority of legislation or case law, they reflect the position under Regulation 32(2)(c). So again, no criticism of that, no appeal against that. We rely on certain statements which are made in the guidance, which the judge has found reflects the requirements of Regulation 32. And in particular, can I ask you to turn to tab 21 of the authorities bundle?
This is from the guidance.
This is the European Commission's guidance.
Is this set out in the judgment? She sets out quite a lot of it. Yes, it is part of her text in the judgment. If it's easier,
Are we still on apparent bias, or are we moving to?
well, I've moved to the submission that the findings on apparent
Yes.
bias cut across Reg 32.
Yeah, so you're still on that.
Yes,
Right.
and there's territory that is also relevant to the Reg 32 cross appeal.
Exactly.
I'm dealing with it.
Well, would it be a convenient moment to pause and then take us to the guidance at 2 o'clock?
Yes.
To the extent we need to see it beyond what's in the judgment. But I think so your submission so far is that by the language she used, the judge adopted the interpretation that the Commission guidance supports, even though the guidance is clearly not law. Okay, good. 2 o'clock then.